it should go to mute, but. Excellent. All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. Before I call this morning's docket, make sure that you are maintaining all social distancing. I encourage you to make use of the entire courtroom. If you are a family unit, obviously you can sit together. If not, I would encourage you to find locations throughout the courtroom that are marked with the orange tape. If you would like a mask and do not have one, please mention it to the bailiff or court staff, and we'll provide one to you. Be mindful of congregating in the hallways, restrooms, elevators in that area. We want you to be safe from those fires, okay? When I call your name, I need you to say present or here and raise your hand so I can see you as well. Bradley Copeland. Jacqueline Jacobs. Jacqueline Elaine Jacobs. Jonathan Lassiter. Christopher Mata. Christopher Jean Mata, M-A-T-A. I have a note that Mr. Mata was to appear via Zoom, however, is not present in the Zoom courtroom at this time. Is it Jaime Zarate? Is it Jamie? Jaime, what do you go by?
I go by
Jaime Zarate.
Would you print me a motion to dismiss?
John Robert Davis. Rachel Leanne Hicks. Shazmin Jones.
Here.
Is it Shazmin or Shazmin? Shazmin. Lori Rush.
Ms. Rush suffered some burns and she is in the hospital.
We'll recall her. I have some more information on that too from the hospital. We'll recall her. Thank you. John Carmona.
Yes, better.
Thank you, sir. Juan Lopez Gomez. Juan Lopez Gomez. Oh, I believe that state's dismissing that case. Is that correct?
Yes, sir.
We'll recall that. All right, Mr. Zarate, I want you to report to your bondsman, Mr. Clay Nicholas here. I want you to meet with him in the hallway before I call your case again. Ms. Jones, I need you to report to pretrial release with Ms. Burns here to fill out some additional paperwork. It will be pretrial release conditions, Mr. Gimbel. And once you sign those, come on up, Ms. Jones. Once you sign that paperwork, then just return to the courtroom and we'll call your case. All right, counsel, do we have anyone that's ready? Not everyone at once. Need you to hold back some of that exuberance this morning. You all have time to speak with the state?
Yes, Judge. I'm just going through my paperwork and I need just a few minutes to visit with my client. Like I said, the surgery will be ready to go.
Okay, that's fine. All right, court's just gonna stay on the bench and work quietly while you work with the state. Court call CR 2258, Jonathan Lassiter. Mr. Lassiter, come make your way to the podium, please.
Judge, I need to see him. He reports nothing. So
All right, Mr. Lassiter, today you are set for arraignment on your charge of driving while intoxicated, third or more, a third-degree felony offense. The court has reviewed your request for a court-appointed attorney. Unfortunately, you do not meet the financial requirements for the appointment of an attorney, so you're going to need to hire an attorney to represent yourself in this case. So what the court's going to do is I'm going to reset you to come back on December 10th. That gives you a little more than 30 days to go out and hire an attorney and bring them back to represent you in this matter, okay? The range of punishment that you are looking at, if convicted of this offense, is a possibility of confinement in the Texas Department of Criminal Justice prison for not less than 2 years or more than 10 years and a fine up to $10,000, okay? So it's a serious charge, all right? So I'm going to encourage you to reach out and hire an attorney as quickly as possible. I'm going to have the bailiff bring you an appearance and announcement form, and it's going to say that we're coming back for arraignment on December 10th and a status for you to hire that attorney. I'm going to have you sign where there's an X and date it, and then we're going to give you a copy. After you sign that and the bailiff hands you that yellow copy, I need you to come up here and see Ms. Burns and report for your pretrial, okay? So let's see, Mr. Mata.
Me last night, late, she had suffered explosions, burn, bad at her home, and she was transported from into the hospital in ambulance and transported to Parkland Hospital in Dallas. And I was able to contact this first this morning, but I apologize, I did not have any documentation from the hospital to authenticate her admission to the hospital, but I believe Ms. Abraham has since spoken to the hospital in Dallas.
Yeah, that is correct. Ms. Abraham has confirmed with Parkland staff that she is there. So what we'll do is we'll reset Ms. Rush for pretrial on December 10th. We'll see if she's out of the hospital and if there's any medical issues at that time, but we'll reset to December 10th at 9 a.m.
Thank you, Your Honor.
And since she is not here to receive her notice of appearance, I'm resting assured that you will provide that to her if I will give her notice. And are you ready on Miss Jones at this time for arraignment?
I believe it's Jones.
She's back.
Then yes, Your Honor.
Have you seen the indictment in that case?
Yes, I have.
Okay, Miss Jones, if you'll make your way to the podium, please, ma'am. CR 20256. Yes, ma'am. This is State versus Shazman Jones, and we're set for arraignment today, Mr. Gimbel.
And I have received discovery and material and the plea offer, and her name is correct, and we have pleaded not guilty.
All right, court will enter Miss Jones' plea of not guilty into the record. Are you available on December 10th?
Yes, I am, Your Honor.
Court will set Miss Jones on December 10th for pretrial. Ms. Jones, you've received a copy of your pretrial release conditions that you signed this morning with Ms. Burns, correct?
Yes,
And you
sir.
know what's expected and required of you.
Yes,
You
sir.
understand that by violating any of those terms of your pretrial release, court could revoke your bond and put you back in jail. You understand that?
Yes, sir.
Okay. If you have any questions or issues with that, I suggest that you discuss those with Mr. Gimbel before you leave, okay?
Okay.
All right. Once you sign the notice of appearance form and receive the yellow copy, court will retain the white copy. Once you receive that, you'll be free to go.
I don't think that's a symptom, though.
No, I think it's just true.
Karen, I'm looking.
Thank you.
One 1719.
Thank you.
Mr. Mata, if you can hear me, it looks like your device is trying to connect to audio, but if you see a microphone on your device that's red and has a line through it, you'll need to click on that to unmute yourself.
You need me to sign off on this, Judge. There is a signature block for us, but.
No, I mean, no, 'cause it's not yours.
Okay.
I'll just, perfect, thank you. Mr. Mata, did you find that mute button? You may have to swipe over to the next screen, or you may have to swipe up from the bottom of your device. There'll be a red microphone button, you'll need to push that button.
All right.
Okay, all right. You are, in fact, Christopher Gene Mata, is that correct?
Yes, sir.
All right, Mr. Mata, this is in cause number CR 2261. Today we are set for arraignment. You have been charged by the grand jury with a state jail felony offense of possession of a controlled substance in penalty group 2, less than 1 gram. The range of punishment for that charge is confinement in the Texas Department of Criminal Justice State Jail Prison for a period not less than 6 months or more than 2 years. Mr. Mata, do you intend to hire an attorney to represent you in this matter?
I don't know, because right now I'm on unemployment. I got laid off in April.
Do you want to speak with my criminal court coordinator to determine if you meet the financial guidelines for a court-appointed attorney?
Yes, sir.
So how this is going to work, Mr. Mata, is I'm going to place you in another room on this system. So whenever you get prompted to join a breakout room, I'll need you to go there. Once you get there, you'll need to speak with Ms. Tabraham and give her some information to allow me to review your financial situation to see if you receive a court-appointed attorney, okay?
Okay. But this charge is a state jail felony? I thought it was a Class B misdemeanor.
What's on my docket says state jail felony. Okay, so while you're meeting with her, I'll double check that and get back to you, okay? So when prompted, I want you to join the invitation, and you'll go and stay online, and you'll be joined by another staff member in just a moment.
Okay.
Just one moment.
I think I'm going Friday night. I've never been. I've heard great things.
Mr. Mata, did you get an invitation to a breakout room?
No, I didn't. I didn't see nothing. Can you try it again? I'm not really how to do this computer stuff.
All right, you should have been prompted to join a breakout room.
Week after next. Oh, yeah. How'd you take it? Got a good guinea pig. It's 2018. The possession child. This guy got see how it goes. Any misdemeanor or something. How big is the central jury room there?
Mr. Nichols? Yes, sir. Then approach, please.
There's no place else they can do it. That's what I heard. Bringing COVID all up in there. Yeah.
And just jump right on mine whenever court's ready.
All right. CR 24-3, State versus John Carmona.
After jury waiver.
All right, Mr. Carmona, want you to raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hands down. All right, you are John Michael Carmona, is that correct?
Yes, sir.
Mr. Carmona, in this cause, you are set for docket call today. And Mr. Sanders, your attorney, has handed to me a document entitled Waiver of Jury Trial. It bears your signature. Is this your true and correct signature on this document?
Yes, sir.
Mr. Carmona, did you read this document and discuss it with your attorney, Mr. Sanders?
Yes, sir.
You understand by signing this document, you're telling the court that you understand that you have the right to have your case heard by a jury of your peers.
Yes, sir.
You have the right to cross-examine and confront the state witnesses before that jury.
Yes, sir.
You have the right to subpoena your witnesses before that jury. You understand that you also have the right to waive all of those rights.
Yes, sir.
And are you asking the court to allow you to waive these rights so that you can enter into a plea agreement with the state of Texas?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to enter this waiver of jury trial?
No, sir.
And you're doing this of your own free will in court, is that right?
Yes, sir.
The court takes notice that the attorney for the state and the attorney for the defendant have joined in with the defendant, requesting the court to waive the defendant's right of jury trial and enter and proceed by plea agreement. Or the state grants the waiver of jury trial in open court. Mr. Sanders, will this be a plea agreement to probation or to time?
It is for time, but Judge, it'll be under 1244A, so it'll be actually the agreement's for 60 days county jail time and then $3,500 fine. And Judge, we were going to ask if we could set it off to do the plea and sentencing after the first of the year, if early January, if that would work.
And are you court appointed?
Yes, Your Honor.
Is Mr. Carmona going to have the court appointed attorney fees and fine or anything paid for at the time of the plea?
I don't think so. We hadn't even talked about that, Judge, as far as any of that.
If I set
probably
it,
say some, pay some.
if I set it in January and being past Christmas, do you believe that he will pay your fees in full?
I think we could get that worked out, Judge. Yes.
That the court would be interested in that.
Okay. Okay.
So I'd be willing to set it off if there's no objection from the state.
No, you're on.
The state has no objection, so if I set it in 60 days, your fees would be, this is a state jail felony, so what, so $500?
Yes.
So I would expect your client to have paid his court-appointed attorney fees by that date.
Okay. I mean, he would just need to pay that through pretrial?
Pretrial release.
Okay. Okay.
And he may have a credit over there. If he's been paying on pretrial release, he may have a credit towards that.
Okay.
But I want to make sure that the taxpayers are reimbursed.
Okay.
All right, court will set Mr. Carmona then to enter his plea before the court on Thursday, January 7th. Do you have any scheduled conflicts that day, Mr. Carmona?
I don't think so. Not yet, anyway, Judge. So that'll be fine.
We'll set Mr. Carmona then at 1:30. We can enter his plea at the jail. All right, Mr. Carmona, once you sign your notice of appearance and receive the yellow copy, you'll be free to go.
Thank you.
Check to see how much credit he had.
Jail time?
No, on attorney fees.
Oh, yeah. Who was it, Carmen?
She's gonna check that.
Okay, yeah, so I was going to ask that.
You go, back there.
Yeah, all right.
Nicholas, do you have that? Yeah.
you, Joe.
Mr. Zarate, if you'll make your way to the center podium. All right, you are Jaime Zarate Jr., is that correct?
Yes, sir.
Well, Mr. Zarate, you are charged with the second-degree felony offense of aggravated assault causes serious bodily injury that carries a range of punishment of confinement in the Texas Department of Criminal Justice for a period not less than 2 years or more than 20 years, and a fine not to exceed $10,000. You have requested the court to appoint you an attorney, and the court has reviewed your financial application. At this time, finds that you are ineligible for the appointment of an attorney. You will need to retain an attorney to represent you in this matter. Okay? So the court is going to reset this case until December 10th at 9 a.m. I'm going to fill out a notice form here. Bailiff's going to present that to you. You'll sign it. It'll have that reset date for you. You need to come back on December 10th with an attorney. Okay, very serious matter. Okay. In addition, your bondsman had requested to go off of your bond and had asked and requested the court to issue a warrant for your arrest. And as you stand there right now, there is an active warrant for your arrest. All right. And the bondsman had filed that with the court saying that you had not kept in communication with him. He was concerned that you were not going to appear. So under the law, he was entitled to request to go off of your bond, and the court had granted that. Mr. Nicholas has graciously requested the court to withdraw that warrant and to be able to stay on your bond. So the court has signed an order today withdrawing that warrant. It's going to be active for a little while until the sheriff's office can pull it off of their system. So it's going to take time to be filed and be sent out to the sheriff's office. So you need to be very careful when you're driving. If you get pulled over, you're most likely going to go to jail. Okay? And if I were you, I would be in constant contact with my bondsman because he holds one of the keys that keeps you out of jail. All right, so your failure to communicate and be overly cautious could result in the next time you come to the court revoking your bond and putting you back in jail. Okay. All right, the bailiff's going to hand you this form here with your reset date of December 10th at 9 a.m.
Who am I looking for, Casey?
Just one moment, Mr. Mata. All right, Mr. Mata, we're back on the record. CR 2261. All right, so you met with my criminal court coordinator, and she has informed me that you do not meet the financial guidelines for the appointment of an attorney for your state jail felony case. I did confirm that the case is charged as a state jail felony. So what the court's going to do, because you do not meet that financial guideline, the court is going to reset your case today. I'm going to give you 30 days to go out and speak to and hire an attorney and bring them to court with you on December 10th. So make sure you write that down. This will be the only notice that you get from the court, is that you're due back here in this courtroom on Thursday, December 10th for arraignment on this charge. Okay?
Okay.
You understand? Any questions?
Yes. When I initially got charged with that, they charged me with a Class B misdemeanor. Did they just upped it by themselves?
I can't.
I called the bondsman, and they said the bondsman they could have done that, but
Yeah, I can't really discuss the facts with you because I have very limited facts, because in my position as a judge, I'm not to have more facts about one side or the other. All I can tell you is that the indictment in the case reflects a state jail felony. What I can do for you is I will show you let me show you the indictment, okay? And then that can give you more information. Just one second.
So you're looking for an offer for Mr. Copeland?
Do you see this document, Mr. Mata? All right, this is the indictment in this cause number. And the indictment reflects a charge under 481.116B of the Texas Health and Safety Code, possession of controlled substance in penalty group 2 less than 1 gram. And here, the specific charge, this is just the naming, but here is the specific charge, that you did then and there intentionally and knowingly possess a controlled substance, namely tetrahydrocannabinols, the amount of less than 1 gram. So this is what the prosecutors have filed. Okay.
okay.
All right. So on December 10th, I expect you to be back in here with your attorney. And of course, failure to appear on the 10th is going to result in the court issuing a warrant for your arrest. Okay.
I honestly say I don't know if a month's enough time, but like I said, I'm on unemployment. I mean, I'm not even getting that much money. And I'm sure the attorney's gonna be a lot of money.
Well, you come back on the 30th and you tell me how many attorneys you've spoken to, how much it costs, how much you have, if you've made any down payments. We'll discuss that all on the 10th, but I really expect you to have an attorney on the 10th. If not, you better have a list of attorneys that you've spoken to and a list of reasons why you haven't retained them and why you can't afford them. Okay?
Okay.
All right, so we'll see you back on December 10th.
Okay.
All right.
I think.
All right, court's going to stand in recess for a few moments, allow the attorneys to finish up the plea paperwork. And then Mr. Copeland and Ms. Jacobs, as soon as we get back, we'll call your cases, okay? And Mr. Davis, I'm gonna have you raise your right hand. I'm gonna place you under oath. Mr. Davis, you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God. So, put your hand down, please. Mr. Davis, you are represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you? Feel like you've had sufficient time to talk with him about your case and have all of your legal questions answered? Is there anything about this plea agreement and the documents that you signed that you do not understand? Are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? Mr. Ashmore, do you believe your client to be competent today?
I do, sir.
And you've explained to him all of his legal and constitutional rights?
I did, Judge.
And you've also explained to him both the advantages and disadvantages of a deferred adjudication?
I have, Judge. We talked specifically about how it's a big carrot and a big stick, and he's got an opportunity to, at the end of this, have a dismissed charge and restoration of all of his rights as a citizen. But he also faces the full range of punishment if he hits a tripwire that messes up.
You agree with that, Mr. Davis? All right, Mr. Davis, you are charged with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. It carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice State Jail Division, and a fine not to exceed $10,000. Do you understand that full range of punishment? You understand if the court approves your placement on a deferred adjudication community supervision, that if you violate the terms and conditions of your probation, the court could, upon finding those violations to be true, could revoke your community supervision and could assess your punishment anywhere within that range. Mr. Davis, how do you plead to that charge? Sir? And Mr. Davis, are you pleading guilty because in fact you are guilty for no other reason? My court accept Mr. Davis's plea of guilt at this time. Mr. Ashmore, any objection to States 1?
No, Judge.
States 1 is admitted into evidence. The court takes judicial notice of Mr. Davis's judicial confession. Is there anything further from the state? From the defense?
No, Your Honor.
Sorry about that, Mr. Davis. All right, Mr. Davis, based on the evidence before the court finds that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement that you've reached with the state. The court defers a finding of guilt in this case, places you on community supervision for a period of 3 years. The court assesses a $1,000 fine, restitution in the amount of $180, court costs of $290. Court orders you to pay reimbursement fees to Van Zandt County in the amount of $985. And Mr. Davis, you've gone over all of the conditions of your community supervision with your attorney, Mr. Ashmore, is that correct? And you understand what is expected and also required, is that right? We've already discussed that if you violate any one of those, the state may file a motion to adjudicate your guilt and to revoke your community supervision. And if they prove that to the court could do a number of things, including revoking your community supervision and placing you in prison up to a maximum 2 years. You understand that? Have you ever been on probation before? A lot of people, I believe, and I think it's probably the common misconception, is that probation is a slap on the wrist. And I can tell you that there's really nothing further from the truth, because it's, in my opinion, it's much harder to be successful on community supervision because you have to be an adult. You have to be responsible. You have to be disciplined. And those that want to make it can make it. It's easier to be locked in a box and be told when to go to the bathroom, when to get up, when to eat, when to go to sleep, like a child. It's much easier to be a child and be taken care of than it is to be an adult and make decisions and support yourself and others and be productive in society. So right now you're being given an opportunity to see, can you be an adult about this? All right. So the ball's in your court now, right? You mess up, it's going to be on you, no one else. Okay. So this is a great opportunity. As Mr. Ashmore said, it's a big carrot and a big stick, and he's right. Okay. So I'm going to encourage you, when you meet your probation officer, that you befriend them and you find out what it's going to take for you to be successful. And you do that. If you do that, then you can move on with your life and get the government out of your life, not the government. You understand? All right. All right, Mr. Davis, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm going to have you step forward here with my bailiff to be fingerprinted. After that, I want you to report to the probation department. You can have a seat over here, and it'll be with you in just a moment. This is Mr. Davis. I guess with his stuff. Mr. Ashmore, on your billing, it says that there were additional $450 additional fees for cases. I didn't see that reflected in the plea agreement.
No, and it wasn't, I don't know if they were dropped, but when it was appointed, it was a 4-case appointment, and that's maybe left over from the prior judicial administration, but that's how I was under the impression that those case sheets were filled out.
State, are there additional charges for Mr. Davis? Any misdemeanors? So your appointment, you were appointed to 4 cases?
That's my understanding, and then the 3 were dropped. And I may have confused that, Judge.
Take a moment.
We only ever received 1 case from Mr. Davis.
I show 4 F numbers. Let me have you look those up from Sizel. This cause number CR20155 is F1862. And then Mr. Ashmore was appointed on F17-656, 00656, F18-00645, 646.
So all of those we closed out in our system.
Were they rejections?
The F17-656 was a rejection. That was also rejected.
rejected it and taken.
All right, so Mr. Ashmore, what I'm going to do is, if you'll approach, I'm going to ask you to amend your motion here.
Absolutely.
And so what I'm going to do is I want to mark out the additional 1245s and please.
Okay.
All right, and so, and then I'm just going to indicate here that they were rejections, and I listed the F numbers. So,
I apologize about that. That's
just initial that.
my understanding.
I just got to keep my accounting straight. If I get audited.
Oh, I didn't even see that. Sorry.
That's why I get paid to see those things. All right. So the court has approved your motion. All right, Ms. Hicks, Rachel Hicks, CR 20123. You'll make your way to the center podium. Is this a plea today?
Yes, ma'am, approach.
You may. Commissioner, did you inquire as to page 6 of 6, if there's any legal significance of that blank page? That's the end of the community supervision. Check with Ms. Burns and see if there's anything that's supposed to be, and I'll give you this. She's through this to her. Ask her if page 6 is supposed to be blank. Six, do you have a bill of cost? Do you have a sheet that's entitled bill of cost available?
Sure.
Can I see that for just a moment? I'll give it back to you. Ms. Hicks, if you will, raise your right hand. I'm going to place you under oath. Ms. Hicks, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may put your hand down. You are Rachel Leanne Hicks, is that correct?
Yes, sir.
Ms. Hicks, are you a United States citizen?
I am.
And do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Casey Ashmore. You feel like you've had sufficient time to talk with him about your case and have all of your legal questions answered?
Yes, sir, ma'am.
Is there anything about these documents that you've read and signed that you do not understand?
No.
And Mr. Ashmore, do you believe the defendant to be competent today?
I do, Your Honor.
And you've explained to her her legal and constitutional rights and the advantages and disadvantages of a deferred plea?
I have, Your Honor. We talked specifically about the waiver of her constitutional right to a jury trial, to an appeal, and the consequences of the violation of the terms of the probated sentence, as well as the benefits of a deferred, which again, it's a restoration of her rights as a citizen, and she understands all of that and is ready to go forward this morning, Your Honor.
Is that true, Ms. Hicks?
It is, yes, sir.
All right, Ms. Hicks, you are charged by indictment with the state jail felony offense of abandoning or endangering a child by criminal negligence. A state jail felony carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice State Jail Division, and a fine not to exceed $10,000. Do you understand that full range of punishment?
I do.
You understand that if the court approves this plea and places you on community supervision, if you violate your terms and conditions and the court receives evidence and finds that to be true, the court can revoke your community supervision and sentence you anywhere between 6 months up to 2 years.
Yes, sir.
All right, Ms. Hicks, at this time, how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty because you're guilty of that for no other reason?
Yes, sir.
Did anyone threatened you, forced you, made you feel like you had to plead guilty to this charge?
No, sir.
Court accepts Ms. Hicks' plea of guilt at this time. Mr. Ashmore, any objection to States 1?
No.
States 1 is admitted into evidence, and the court takes judicial notice of Ms. Hicks' judicial confession. Is there anything further from the state? From the defense?
No, Your Honor.
what's the current status of the child in the TPS investigation, if any?
Judge, my understanding is from Ms. Sales, I'm not involved in that case, but I'm aware of it. And it was Ms. Sales' case while she was here at the district attorney's office, is that this is the 1% downstairs in the CPS court. Ms. Hicks has excelled in meeting all of the expectations of the Department of Family and Protective Services. The plan is restoration. If I'm not mistaken, child, your son is already home?
No, sir.
Not yet? Okay, but on the path to making all that happen, which is one of the reasons why, I've never seen any defendant receive an offer where the offer includes, if you keep this up, the state will support an early discharge. So my understanding is that Ms. Hicks case is the exception to what we see in the Child Protective Service court. I've never seen a restoration, let me just put it that way, for any case I've been on down there.
Where is your son at this time, Ms. Hicks?
It's in foster care.
Is he in Texas or is he in Alabama?
Yes, sir.
Texas. And are you working your services with the department?
I am. And then some.
So, good. All right, based on the evidence before the court will find that there is sufficient evidence to convict Ms. Hicks of this offense. However, the court will follow the plea agreement reached with the state. The court hereby defers a finding of guilt in this matter, places Ms. Hicks on 2 years community supervision, assesses a $1,000 fine. Court orders her to pay court costs of $290, reimbursement fees of $565. Ms. Hicks, how many children do you have?
Just,
Just one? And that's Abel, correct? Is his name Abel?
yes, sir.
And how old is he now?
He's 4.
He's 4. How long has it been since you've been able to be mom day in and day out?
The case started in March, I believe, of this year. Proceeding to stay open for the year, and then next week on the 12th is when we'll go to do the return, to start back into the return process.
Are you looking at a monitored return? Is that what you said?
Yes, well, it's going to be the last case before the ending in January. So right now the status is in adoption, the family adoption, and then they'll change it on the 12th to return.
All right, Ms. Hicks. It's going to be a little bit of an uphill struggle for you, okay? We'll place you on community supervision, and the probation department, they're going to give you all the resources that you need and the support you need to be successful. Understand that you've got 2 things over your head at this time. You've got your own liberty to worry about, and that's violating your community supervision. And if you have a drug problem, that's going to be something that you're going to battle perhaps for the rest of your life if you have an addiction. So you need to reconcile with that and understand that. That liberty is one thing, but I think probably the most important thing is your child. Having that relationship, that parent-child relationship with your son. So I think if you'll prioritize, I know if you'll prioritize that relationship, it'll make the probation conditions, the probation conditions will pale in comparison to what you've got to do to get your son.
Yes,
Okay.
sir. I'm utilizing all the tools they're giving me.
Good. So I want you to keep that up and don't let any of the pressure, get a job or stay clean, these things overwhelm you. If you need help, now's the time to get it. And if you want to be a mother to your son, then it's going to take you being clean. It's going to take you being a fit parent that can provide a safe environment for this 4-year-old little boy. Okay? I'm not telling you anything you don't know. I'm just reminding you and telling you that if you want to do it, you can do it. right? But it may not be easy, but now you've got to decide, is it worth it? Is he worth it? Is your liberty worth it? Okay? All right, Mrs. Hicks, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward here to be fingerprinted with my bailiff. After that, I want you to report to Ms. Burns over here with the probation.
Who's his lawyer?
Ms. Heisel, do we expect Mr. Ashmore, are you ready now on Mr. Copeland?
Yes, Judge. I approach.
Yes. Mr. Copeland, if you'll make your way to the center podium, please. CR 18360.
Please. Oh, no, I don't. That's withdrawal.
Yes.
State withdrawing is motion to adjudicate.
Yes, sir.
You already, are you already filed that?
Yes, sir.
All right, Mr. Copeland, this is in cause number CR 18360. The state has filed a motion to adjudicate and revoke your community supervision, but it appears to me that you've reached an agreement with the state. This time I ask you to raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, Mr. Copeland, you can put your hand down. Mr. Copeland, your attorney is Mr. Casey Ashmore. You feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
And Mr. Copeland, you were previously placed on community supervision by this court, and the state has alleged that you have violated the terms and conditions of your community supervision. And the state has indicated to the court that it will request the court to withdraw its motion to adjudicate based on your agreement to do several things. One, that you will be required to participate and successfully complete intensive supervision, that you will be reporting weekly during the first 9 days of your intensive supervision, that you will attend weekly peer support at the probation department and weekly group counseling. That's going to have additional costs that you're going to have to pay. That you will submit to polygraph tests before the completion of your intensive supervision, with you being responsible for the financial fee for the polygraph. And in addition to that, that you're going to serve a term of 16 days in the Van Zandt County Jail, beginning weekend commitments beginning Friday, November 13th, and then occurring successfully November 20th, November 27th, December 4th. Is that your agreement in this case?
I thought it was 12 days. It's 4 weekends. With the Friday through the Monday, it's 16 days.
You'll get credit for Friday night and Monday. But it says 16 days to be served on the weekends with you entering at on 6 p.m. on Friday, November 13th, November 20th, November 27th, and December 4th, with you being released at 6 a.m. on the Monday thereafter. So you'll get 4 days credit. Is that your agreement? Has anyone threatened you, forced you, or pressured you to enter into that agreement? All right, then court will approve the amendment to the conditions of community supervision. The court will grant the state's motion to withdraw the motion to adjudicate him. All right, Mr. Copeland, I haven't gone and reviewed what the motion said. I didn't go and read, but I can only imagine, since you're standing here today, that it must be quite serious if they're requiring jail time and putting you on intensive supervision. So whatever issues you have going on, now is the time to get those resolved. It seems like you have another bite at the apple today, that you're not standing there in an orange jumpsuit and handcuffs, looking at 2 to 10 years in prison. Okay, so I would take full opportunity of what's being given to you, and I wouldn't come back, because I doubt the state's going to be as willing to give you more opportunities. And at some point, the court has to draw the line on whether or not you're going to be successful in the community, because that's where you're at. Okay, good. All right, Mr. Copeland, you're hereby remanded back to the custody of the Community Supervision Corrections Department. You can go ahead and step over here and meet with probation.
Have you excused your honor?
Yes, sir, and I've approved your motions to pay.
Thank you very much, sir.
Y'all hear from Mr. Copeland? Okay, he's just gonna meet with the probation department, and then they'll bring him out. If you want, you can have a seat here in the hallway. He'll be out shortly, okay?
No, sir, but we have
I'm
this
used
one
to,
for
well, I
2 days
never get a
ago.
copy of it on this e-file, so that's fine. And sometimes it falls through the cracks.
All right, court's gonna stand in recess until 1:30, and we'll resume at the Banton County Justice Center. Do you anticipate you'll be in person or Zoom? Person. Okay.
Yes.